Welcome to the Anthony John Esquire podcast. I am AJ. It's been just a week since Agent Jonathan Ross shot and killed Renee Good in Minnesota. Adrian Allen is a firearm instructor and police use of force expert who joined me for an over 3-hour conversation about this case. Adrian did a wonderful job of presenting the best case that Agent Jonathan Ross was justified in his shooting of Renee Good, and here I'm going to endeavor to recap that best case and rebut it. It should go without saying that there's a lot we don't know, and that notwithstanding the case I present to the contrary, Agent Ross is presumed innocent unless proven guilty in court. The possibility of that might seem in doubt, not because he's innocent, but because federal law enforcement has presumed to take over the investigation, shutting the Minnesota state government out and insisting, rather absurdly, that he is absolutely immune from prosecution, which isn't really a thing. All the same, as we discuss this, do be mindful of Agent Ross's presumed innocence. Now, on to my summary of why I believe the ICE agent should be charged and tried and would be found guilty. The best form of the argument for Agent Jonathan Ross is that Renee Nicole Good was violating federal law in the presence of federal ICE agents by obstructing them for 3 minutes, that federal law enforcement was effecting a lawful arrest of her for that reason, that Agent Ross was in the path of Ms. Good's vehicle, that when the vehicle began moving forward, Agent Ross reasonably believed he was in danger of death or great bodily harm, and that he used force to terminate that threat. Now, I absolutely do not concede that all of the facts just outlined should be viewed in the light most favorable to Agent Ross. But I could. Because there's just one more bit that's necessary to exonerate Agent Ross in this view of the best form of the argument most favorable to him, and that's that the force he used was reasonable and necessary to terminate what he perceived to be a threat to his life. And there's simply no credible way to make that case. Here's why. A half-ounce bullet cannot stop a 4,000-pound car. So if the threat is the moving vehicle, firing the gun cannot be reasonable and it cannot be necessary because it cannot accomplish the thing it's supposedly for. Impossible can't be necessary. Understandable? Maybe, but that's not the legal standard. The standard is reasonable and necessary. The model jury instruction for self-defense in the Eighth Circuit is, if a person reasonably believes that force is necessary to protect himself from what he reasonably believes to be unlawful physical harm about to be inflicted by another, and uses such force, then he acted in self-defense. However, self-defense which involves using force likely to cause death or great bodily harm is justified only if the person reasonably believes that such force is necessary to protect himself from what he reasonably believes to be a substantial risk of death or great bodily harm. So for self-defense, Agent Ross would have to reasonably believe that the force he used was necessary to protect himself. But it wasn't. It couldn't be. It could not possibly protect him from a moving vehicle. And in fact, it could only make things more dangerous for everyone around him, something even the government's own policies recognize. That's the tightest version of why any self-defense claim Agent Ross might raise must fail. That is me conceding all the facts in the light most favorable to him, stripped of politics. If the force used could not possibly protect him, it cannot be reasonable, and it cannot be necessary. And it gets worse for him. The Eighth Circuit also notes that although a defendant asserting self-defense isn't required to retreat, the availability of retreat may be considered by the jury in deciding whether the force used was reasonable. In plain English, the jury can consider whether he could have safely stepped out of the way. And here, that is fatal. All he had to do was step aside. Under that standard, Agent Ross might not even get to submit self-defense as an instruction to the jury, because he could be regarded as an aggressor who failed to withdraw from a conflict when he could do so safely. Even if you don't like calling police aggressors, the retreat point alone is enough. He had an obvious, safe alternative. He didn't take it. Now, for what it's worth, I don't agree with many of the facts stated in the light most favorable to Agent Ross. It wouldn't matter because of what we've already covered, but let's review anyway. Was Renee Good violating federal law? Was there reason to believe that she committed a felony? Probably not. ICE is permitted to arrest, even a U.S. citizen, if the person commits a federal crime in their presence, or if agents have reason to believe the person committed a felony and may flee before a warrant can be obtained. That's 8 U.S.C. 1357. It's also supported by the Code of Federal Regulations, which I'll get into in a bit. But the lay accusation here is obstruction. So let's walk through the three most likely obstruction theories and why none apply. First, obstructing an officer under 18 U.S.C. 111. That requires force. The statute covers anyone who forcibly assaults, resists, opposes, impedes, intimidates, or interferes with a federal officer performing official duties. And the Eighth Circuit model jury instruction makes the point plainly. Forcibly means by use of force. Whatever word you use, resists, opposes, impedes, interferes, Renee Good did not. If someone wants to argue that force applies later, when she drives forward, they've missed the point. We're talking about the agent's asserted basis to arrest her before that, before they approached her door. So subsection 111 doesn't fit. Second, obstruction of a federal proceeding under 18 U.S.C. 1505. This does not require force. This is the statute Judge Hannah Dugan was convicted of in Wisconsin. While the Eighth Circuit model instructions don't have a dedicated 1505 instruction, the DOJ treats 1505 and 1503 as parallel, and other circuits' instructions on 1505 are substantially similar. For 1505, you need three things. One, a proceeding before a department or agency of the United States. Two, the defendant's awareness of that pending proceeding. Three, the defendant's intentional and corrupt obstruction of the proceeding's due and proper administration. This is the closest theory that someone can point to, and it still fails. In Judge Hannah Dugan's case, part of the evidence was that she knew ICE had an administrative warrant for a specific immigrant in her courtroom. From that, you can at least argue she knew there was an enforcement process underway. Here, we don't have that. We don't have evidence of a proceeding. We don't have evidence Renee was aware of one. And even if you could prove there was some pending federal proceeding connected to ICE's presence, you cannot show awareness of it on her part. But the hardest part is corruptly. The Eighth Circuit explains that corruptly is a heightened mens rea, guilty mind, associated with wrongful, immoral, depraved, or evil acts. And the Supreme Court has equated it with consciousness of wrongdoing. In a nutshell, you'd have to prove that Renee knew ICE was engaged in lawful conduct and that she obstructed it with consciousness that she was doing wrong. I don't believe there's any universe where you can show that. It's a non-starter. Third, Minnesota's obstruction statute. Minnesota statute 609.50. That makes obstruction of a peace officer a misdemeanor unless it's accompanied by force or a threat of force or creates a risk of death, substantial bodily harm, or serious property damage. Here, that doesn't get you to a felony. And ICE's arrest powers are limited to violations of federal law or state felonies. So, was she committing a crime that ICE could arrest her for? No. She was not committing a federal crime, and she was not committing a state felony. Therefore, ICE was not engaged in a lawful arrest. At best, they were engaged in an unlawful arrest. Now, some of you will ask, people get to just block traffic and we have to deal with it? No. People can't legally block traffic. But ICE can't legally do anything about it either. If Agent Ross wanted consequences, he could have called Minneapolis police. Or he could have sent his video to Minneapolis police or the Hennepin County District Attorney. They could have tried to charge misdemeanor obstruction, and Renee Good could have faced appropriate consequences for whatever she did. But we limit government authority all the time, and here we've limited ICE's. And even if ICE had been engaged in a lawful arrest, they were still required by law, not policy, to conduct the arrest in a specific way. As soon as it's safe to do so, they must announce that they are federal law enforcement, that they're empowered to make arrests, that they are making an arrest, and what the arrest is for. That's 8 CFR subsection 287.8 sub C sub 2 sub 3. And it is not subject to reasonable dispute. There's no debate that if you have time to say, get out of the car, get out of the car, get out of the fucking car, get out of the car, you have time to say, I'm ICE. I'm empowered to make arrests, and you're under arrest for obstruction. And if you think I'm being too hard on ICE for not knowing that regulation, keep this in mind. Their arrest authority under the Code of Federal Regulations requires training and certification on exactly that. That's 8 CFR, Code of Federal Regulations, subsection 287.5. So, what did they actually do? They approached abruptly. They didn't identify themselves. They made demands using profanity without explanation. They tried to forcibly remove her from her car. There was nothing legal about this attempt at arrest. So not only did they lack grounds to arrest her, they also attempted to conduct the arrest illegally. Next, Agent Ross's position in front of the vehicle. Even viewing it in the light most favorable to him, it doesn't hold up. He chose that position. No one moved him there. And there's no intelligent explanation for why he stayed there. And beyond the unlawful arrest and the unlawful manner of arrest, there are clear violations of policy and training that fall squarely on Agent Ross. As Adrian explained, Ross was still in front of the A pillar of the vehicle. Law enforcement are trained not to place themselves in front of vehicles. And Customs and Border Protection in El Paso, at the very time Ross served there, was criticized for repeated instances of agents placing themselves in front of vehicles so they would have an excuse to shoot. That's not subject to interpretation. It points to something darker than split-second judgment. Next, the claim that Ross reasonably believed the moving vehicle posed a risk of death or great bodily harm. The Supreme Court of the United States recently made clear in Barnes versus Felix that we don't look only at the instant of the shooting. We consider the totality of the circumstances, including what led up to the shooting. So, officer created danger matters. Even if it isn't the sole dispositive factor, it's part of the totality. And in Ross's own video, the totality cuts against him. As he walked around filming her, Renee Good said, "I'm not mad at you." And there was an old dog in the back seat. And yes, she was a white woman, not exactly the demographic police claim they fear most in these encounters, especially when you consider their relative conviction rates compared to other demographics. And right before Ross fires, you can see her crank the wheel hard to the right. So no, the totality does not support the claim that Ross reasonably believed he was in danger of death or great bodily harm. If he actually believed it, which is doubtful, his belief was unreasonable. And what he did immediately after the shooting, calling her a fucking bitch, then fleeing the scene, combined with known criticisms of Border Patrol tactics in his region at the time he served there, the evidence points to something much darker going on in Agent Ross's mind. Finally, the force itself. If Agent Ross is charged, the jury won't be instructed that he's fine if he acted in accordance with department policy. They'll get the self-defense instructions we've discussed. But even if he wanted to smuggle agency policy into reasonableness, he didn't follow that either. The Department of Justice's Justice Manual says firearms may not be discharged solely to disable moving vehicles. And it says you may not discharge a firearm at a moving vehicle unless either the person is threatening deadly force by means other than the vehicle, or the vehicle threatens death or serious bodily injury, and no other objectively reasonable means of defense appears to exist, including moving out of the path of the vehicle. That is verbatim in their manual. Put simply, there is no defense in law or policy for Agent Ross. He remains innocent until proven guilty, but while the federal government seems determined to shield him from prosecution, he deserves to be charged and tried. We deserve for him to be charged and tried. Let's not end there, though. Let's talk about why we're so eager to give cops the benefit of the doubt. Cops who are trained, certified, and armed by the state. Imagine Renee Good really was in a position to kill Agent Ross. When he drew his gun under ordinary self-defense principles, she would have been entitled to run him over, to terminate the threat, because someone drawing a gun on you creates a reasonable fear of death or great bodily harm. And there is no caveat in law that says, unless it's a cop, then you have to meet a higher standard. We have to be honest about what's happening here and why cases like this keep happening. This didn't occur in a vacuum. Agent Ross didn't wake up one morning and decide on his own that American streets were battlefields and citizens were enemy combatants. He was told that. He was trained into that mindset. He was empowered by a federal administration that deliberately blurs the line between law enforcement and warfare. Donald Trump has been explicit about this. He deployed ICE as a domestic occupying force. He sent agents into American cities masked, unmarked, and unaccountable. He described Chicago as a place that would find out why it's called the Department of War. He told military leaders that American cities would serve as training grounds against the enemy within. When you tell armed federal agents that they're at war with their own population, you should not be surprised when they start acting like soldiers instead of police officers. And when that happens, people die. Renee Good did not die because of a split-second mistake. She died because the federal government has embraced a model of law enforcement that treats dissent as hostility, protest as obstruction, and civilians as threats to be neutralized, rather than citizens to be protected. That is not law enforcement. That is authoritarianism wearing a badge. We are told reflexively to give officers the benefit of the doubt. But the benefit of the doubt has become a one-way ratchet, endlessly extended to the government, never to the citizen. That inversion is profoundly un-American. Our constitutional tradition does not rest on obedience to power. It rests on resistance to it. Agent Ross chose to stand in front of that vehicle. He chose to draw his weapon. He chose to fire. But those choices were made inside a system deliberately designed by the Trump administration to encourage confrontation, escalation, and fear. If this country is going to mean anything at all, then federal agents who kill civilians must be subject to the same laws as everyone else. No immunity, no special carve-outs, no wars against the public. Renee Good deserved better. And if we allow this administration's vision of policing to stand, she will not be its last